this morning's docket. Case number 114096 in the matter of Deborah Jean Fickler.
May it please the court, Stan Hazard, appearing for the Disciplinary Administrator's Office. This is another case where I've filed a notice of substitution of counsel because Mr. Walczak handled this case at the panel hearing level. And Mr. Walczak obviously now is retired. Excuse me, there was a panel hearing in this case on May 19th of 2015. The respondent in that matter failed to file an answer but did appear and obviously has appeared here today. The misconduct in the case involved the failure of the respondent to diligently process an appeal in federal court in a criminal case. There were 3 extensions of time which she requested, and no brief was filed, and then she failed to respond to an order to show cause issued by the court, and then she did not cooperate in the investigation of this disciplinary matter. The panel found violations of diligence, expediting litigation, conduct prejudicial to the administration of justice, and failure to cooperate in the investigation. Our office recommended indefinite suspension retroactive to the date that the respondent was administratively suspended by the Kansas Supreme Court on September 18th of 2013, which would make her eligible to apply for reinstatement in less than a year, September of 2016. And I think that's the appropriate discipline. I think, and the court should be aware, it's in the record that the defendant, the respondent's client, was able to ultimately pursue his appeal when new counsel was appointed. So that he did not lose that remedy. But there really is not a lot of a record here for you to make a determination, and Ms. Fickler is going to have the opportunity, obviously, to address the court today and tell you what's going on in her life. But if you read the transcript, there's not a lot of discussion about what was going on or why this occurred. And I think under those circumstances, certainly a reinstatement hearing would be appropriate for the protection of the public, should Ms. Fickler decide that that's what she wants to do in the future.
You're going with a 1-year suspension, retroactive, and so once our opinion comes out, she can automatically apply for reinstatement?
No, sir. We recommended indefinite suspension, retroactive to the date she was administratively suspended by this court, which occurred on September 18th of 2013, which would make her eligible to apply for reinstatement next September of 2000.
All right. Thank you for clarification. Any further questions? Any further presentation?
No, sir.
Thank you, counsel. Ms. Fickler, would you care to be heard?
First, I'd like to say thank you for having the opportunity actually to be heard on this matter, and also that I agree with the panel's recommendation. At the time that I was working on this case, I had left a major law firm. My practice was patent and trademark litigation and prosecution. I became very dissatisfied with my career in law, feeling like I was not doing good. And that is the reason why I went into the practice of law. I left the law firm and tried my hand at criminal law, which was this was a federal case, so it's an eye-opening experience for myself, traveling to jail, interviewing your client in a tiny little room. I always met with my client face-to-face because I am hearing impaired and could not understand him through the plexiglass and talking. During my first meeting with him, he made threats initially about his previous attorneys that were appointed for him, about them having their hands broke. He made reference to this multiple times. Of course, I just assume it's just talk. We did go to trial with the case. During those times, he continued to make small threats. I did alert Homeland Security and the FBI, who were the ones who brought his case of a felon in possession of a handgun. After we tried the case and he was found guilty by a jury, it was actually a jury trial. I live in a fairly kind of a rural area outside of Lawrence, Kansas. We have a small acreage and a large shop. Our shop was shot with a shotgun. I did notify the FBI and Homeland Security of this. I have no idea if it was related to him because I cannot prove that. After his case, well, actually, right before trial, I decided that this was probably not the best career choice for me, and actually went back to school in Kansas City. My first job was as an engineer for 10 years, so I returned to school at Research Medical Center. I attended their School of Nuclear Medicine Technology, and during that appeal was right at the time that I was in school, and I can't put a positive spin on it because I did neglect my duty and I was over my head and did not seek the proper advice of how to get another attorney to replace myself. The court did replace me, appoint another counsel for the client. I'd like to point out that I am inactive in the state of Missouri for practice of law. I have registered as inactive in the state of Illinois, and I have been removed from the United States Patent and Trademark Office registry. And I can always petition again to be a member of the registry with an active bar registration. And I appreciate the possibility of being able to petition to become an active member of the bar in the future. Any questions?
Do you plan on doing that?
Pardon?
Do you plan on seeking readmission at some point in the future, or do you see your future not in the law?
No, I don't see my future in the law. No, not unless I had an employer that I'm in the medical field now. I don't know.
And that's what I was going to ask you. What are you currently doing?
Yes.
You're in the medical field, medical arena. What do you do?
I'm a nuclear medicine technologist. So we do molecular imaging.
Thank you.
Any further questions? Any further presentation? From you?
Nope.
All right, thank you. That concludes case number 114096. The court will take this matter under advisement.